Good afternoon, everyone. Welcome to the Legal Advice for Business webinar in relation to COVID-19. Sorry, we're a couple of minutes late getting started. I've just let the numbers tick up. We're sort of on our way in excess of 30 at the moment. We'll just see where we end up for another 1 minute and then we'll get started. I will give you the heads up for those of you who thought you were joining today because it was because we're going to deal with the landlord-tenant relationship. We've put that back for 24 hours for the main reason that there's whispers that there may be a stimulus package announcement either this evening or tomorrow in relation to commercial rent. And we really wanted to be armed with that information before we took you off on a tangent in relation to force majeure clauses, frustration arguments at common law, and also other sort of minor technicalities that are probably unlikely to get tenants the remedy they want. If there is a Commonwealth Government step in that can aid both landlords and tenants, that would be the best case scenario. So what we're going to deal with today is we're going to deal with the debtor-creditor relationship and touch on solvency issues again in relation to the stimulus measures from Sunday the 22nd. And then we're going to deal with credits and refunds where you're partway through or you've ordered or your customers have ordered goods or services from you, including events, fitness industry, etc. Where we're headed with the webinar series generally is tomorrow we'll deal with the leasing landlord-tenant relationship. Friday, we're going to have a recap of lockdown generally, what we've learned in relation to more specific detail around the stimulus. After that, after Friday, we'll probably drop back to 1 or 2 sessions a week, just update throughout the rest of March and throughout April, purely and simply because the major legal issues will have been dealt with and client need probably trumps our client need on more specific detail that's coming out of these webinars is probably necessary. So before I kick off on the debtor-creditor relationship, does anyone have any general questions in relation to some of the topics from the last couple of days, so stimulus and employment, or anything more generally that I'd like to cover? Obviously, overnight we've seen an extension of the lockdown laws, not to be confused with the old lockout laws, but the lockdown laws. So obviously now extending to hair salons up to 30 minutes, some beauty and massage places, and the alike. So many businesses are now seeking to access stand down protection under the Fair Work Act. All right, no questions, so let's just move along. As Olivia mentioned yesterday and I did on Monday, anything we say here is general in nature. We've had a lot of really specific questions coming in. We are sincerely sorry that we can't get to all of that level of specificity, but really the best we can do in this 45-minute window is hit some big ticket items, hopefully share with you some government links, and then maybe answer sort of half a dozen questions. Beyond that, unfortunately, you can speak with your accountant's a great port of call, your existing legal advisor, or alternatively us if you need someone. So that's kind of where we're at on that point. All right, so I've got 2 questions here. I'll just deal with these straight off the bat. My preference, as opposed to some other presenters, is to have questions throughout. I think the open dialogue is better. And if you guys have got urgent things to move on with, you can jump off quickly as well. So that's good. So the first question is not clear about the link between has been said we need to keep employees. Not clear if that means all employees or at current wage. So I'll elaborate on that query a little bit. My starting comment is that you don't need to keep any employees where you can't afford to. I don't think anyone said that the businesses in Australia need to retain workforces to the detriment of a business being able to rebound in July, August, September, October, whenever that hopefully may be. What has been said is that you need to see where you fit in terms of how you let those employees go, whether it's a stand down as a result of a government imposed stoppage, whether it's a leave without pay on a discretionary basis, whether it's a reduced work capacity by agreement, or whether it's a fully fledged redundancy. Now, I think the question's been clarified for me. And I think what the follow-up question is, does the employer lose the cash flow stimulus, i.e. the 50,000 or up to 50,000 first stimulus this side of the financial year, and the up to 50,000 stimulus in July through October? The comment I would make there is that the stimulus, the 50,000 stimulus, is based, and it's a good question, it's the first time I've turned my mind to it. The stimulus is based on your March BAS. So if your PAYG in your March BAS is down because you made people redundant or terminated, them today, for example, then you would lose six or 7 days worth of wages, and therefore PAYG would not be applicable. Therefore, your stimulus would come down proportionately. Now, what's the real mathematical effect of that? Well, it's twofold. For the businesses in Australia that are using the ATO as their bank and are in arrears and are on payment plans, the stimulus is a little bit of a myth because, I mean that respectfully to the government, but it's factual. I was clarified on Monday by a helpful participant who said, no, you don't actually get it as a cash payment. In the first instance, it comes off your back. So that's a big difference for those of you, which is a large who are on their BAS portal. So whilst your stimulus would be reduced proportionately because of your March PAYG was a lower number, firstly, that would mean that you don't have to pay out the additional week's wages. And secondly, if you have got debts to the ATO, you're not going to see the money anyway. So does it really matter? Probably not. You probably need to consider the decision for your proper staffing requirements as at this week. On that note, I'd say we're seeing a huge amount of knee-jerk reactions where people are absolutely taking this to their workforce. I'm not speaking from a position of anything like that. It does depend on your financial position. But the position we're seeing most of is that businesses are just really, really frightened. They don't see this bouncing back anytime soon. And across a large number of industries, not just B2C providers, but trickling down into the B2B environment, at best, they see their workflow through to maybe the end of April or something of that nature. So if you're not in that camp, which is the majority of the people we're speaking to, that's awesome. And we wish you the absolute best in continuing to employ and engage in the economy. I would say, however, though, if there are businesses that do have some cash reserves, quick decisions often result in issues in the circumstances. So take your time. If you can afford a week to make role is what, then you will end up with a far better outcome and a far better position, I would have thought. And that person is also clarified to say that in Victoria there's a payroll stimulus, which is correct. Victoria is one of few states, I think WA as well, it's in the slides, that actually gets money back, whereas New South Wales is a deferral or a waiver, but definitely in the slides. Got a comment here as well. Can we modify our gym product to online and still charge our clients? That's a really important, that's a really, really common question. There's a huge amount of fitness participants in this webinar series, from 500 club participants through to single owner PTs. So let me deal with that when we get down to the slides in relation to the consumer law, because it is squarely today's topic. All right. We did send out the slide deck last night to all participants. If it didn't come through in the email, let me know, and we're obviously circulating it daily. And we are just treating it as a bit of a working document. So as the lockdown changes, the PowerPoint notes change, and so on and so forth. I imagine probably by mid next week it'll be at its completeness. I think we'll probably know almost the finality of it, if not the end of next week. Just ticking through to the stuff that's been dealt with over the last couple of days. I started with a shirt on Monday. I think I'll be in a singlet by Friday if the COVID-19 hotline doesn't stop. And when I say that, I definitely mean it in lighthearted fashion, and don't take anything away from the people that are really sick and suffering from a health perspective. All right, so consumer law, cancellations, credits and refunds. So interestingly, I had a question this morning from a client who, anecdotally from a client who has purchased a luxury car, currently being manufactured in Europe and due to arrive sometime mid-year when it was ordered, and is now unclear when that vehicle may arrive in Australia. I won't go too much into detail on the specifics on the webinar, given the value of the vehicle and the dispute that may ensue. But there's some of the practical issues that are coming out of this, and whether things like what is a reasonable time to postpone goods or services, and for example, if that vehicle was now not delivered until January 2021, would that still be acceptable to the customer? So let's have a look at it in the context of goods and services and what happens. Now, the Australian consumer law, it's important to note that people say, oh, well, I'm not a B2C operator. That doesn't affect me. Don't worry about it. Turn off the webinar, and you're more than welcome to. But the reality is that the Australian consumer law applies to small to medium enterprise as well, particularly for items up to 40,000 in value, particularly for motor vehicles and other registrable pieces of equipment. And it dovetails into what we call the unfair contract provisions as well. The ACCC have been pretty vocal about this, and you'll see on the next page there is a link to their COVID-19 update. Okay, so the starting point is if your customer, be that consumer or a B2B transaction within the threshold, if they cancel for no reason, then it'll be governed by your terms and conditions. Hopefully you've had some decent terms and conditions in place, you've taken an appropriate deposit, and you'll be entitled to either retain that deposit and or charge the full freight of the goods or services. On the flip side, if you said, well, no, on the flip side, if you said, no, we're a hospitality venue, and before Sunday, we decided that we were going to close just out of our own volition, but you'd paid an event deposit, then that would be a voluntary cancellation by the supplier. And under the consumer law, because that supplier had no intention and had voluntarily taken away its intention to supply the good or service, then there would have been a full refund available to the customer. Probably the most common scenario now that we're seeing is this concept of government restriction. So whether it's the most common examples that we've heard of over the last 72 hours are fitness businesses with recurring memberships, either paid in full or paid periodically. Events businesses in the hospitality space that can no longer conduct the event. And then obviously I got the luxury motor vehicle one this morning, but we're having a few of that nature. And if anyone else has got any, feel free to start to ask away. So if there is an instance of government restriction, basically the consumer law says, well, neither party is at fault. Each party's hands are basically tied, which means that the consumer law is not going to step in and impose a refund position without checking the terms and conditions first. Now, if the terms and conditions are entirely silent, then the ACCC have put out a publication that basically says, well, we think that the supplier, the fitness business, the fitness business, the events business, etc., should provide a refund or a credit. A lot of terms and conditions that we've reviewed over the last few days do deal with this very point, and they say something along the lines of, if the supplier is subject to a force majeure, and then obviously it's important to check the definition of force majeure, but if the supplier is subject to a force majeure, then the supplier will be entitled to retain any deposit and money is paid today. That's probably the most common example that we see in this situation. There is, however, one really, really important catch, which is something that we've seen in relation to the fitness industry. We haven't seen it yet, the fitness industry and other subscription industries. So there's an offence in the Australian consumer law that says there's a penalty to charge for something that you know you cannot supply. So the simplest and most common example of that we've seen in the last 72 hours is, can a fitness business continue to charge membership fees in advance when it knows, so it charges it on the 1st of April until the 14th of April, when it knows that that fitness business will be closed for that period? The answer is entirely not. You cannot charge under the Australian consumer law during that period. I've just got two other questions. I'll just have a quick look. I'm not sure if anyone can hear the music in the background, but my neighbour is clearly not a business owner. Can we hold off shopping rental obligations for April if the centre has not yet approved rental abatement in writing, even though I've been advised over the last few weeks via email? Okay, so I've had a question in relation to rental abatement, and can you simply withhold even though it hasn't been resolved and there's no stimulus been announced? Technically under the lease you cannot. So technically under the lease, under 9 out of 10 leases that we would review, there would be no right to abate for the circumstances that we're seeing. Your abatement without agreement could result in a repudiation or at least a breach of an essential term of the lease. And it could, in theory, entitle a landlord to come and lock the doors. Now, would I be lying to you if I said that people aren't doing it anyway? Yes, I would. But you need to assess your own risk appetite. And again, our strong recommendation is that you get on the front foot and have the conversation with the landlord, because those that go rogue will probably end up worse off in 3 or 4 months' time, when discussions around rent reductions, turnover rent, how the market's performing are being had. So be a good business citizen, I guess. Have the discussion. If you legitimately can't pay for April, then that's another thing, but I wouldn't unnecessarily hold back. All right, what other questions have we got? Yeah. Okay. So I've got a common theme of cases here coming in from some fitness businesses in relation to going online, and the amount of workouts that I've seen, the amount of workout businesses I've seen in a Facebook stream over the last few days that they're launching for the first time online is great, and that's some of the good stuff that you do see out of situations like this. You see businesses diversifying. You see us putting on a webinar, something that we've talked about for 4 years, but we've never made the time to do. That's the good thing about pressure. It forces you to do stuff you can't. The questions that we're getting, and the two that are here in front of me at the minute, are, and I'll skip to the next slide because we deal with it, but can a fitness business say, well, we were providing you group training down at the beach, or we were providing you, or you were coming into our studio and training in a group, or you were coming in after your night shift and training in our 24/7 gym. Can we now provide you with online material to supplement that and continue to debit your membership? The ACCC have taken a pretty firm view on it. We have heard that they have already written to one large Australian-based international fitness franchise to say, you've pushed all your people into an opt-out arrangement in relation to your online course. That is not okay, and we require you to rectify it immediately. What does opt-out mean? You all have been through web checkouts and the alike where things are pre-ticked for you to say, yep, I agree to that, and I must untick it in order for it not to apply. Used to see it a lot, I recall, in relation to airline bookings, and for example, the baggage would be automatically ticked, or the travel insurance would be automatically ticked, or the carbon offset would be automatically ticked. I think that now that's all flipped back the other way, so you have to actively go and tick yourself, but it won't let you get to the next page until you've made a conscious decision. That's the kind of thing that we're expecting to see from you guys as fitness providers, that you give if it's an entirely, from the ACCC's perspective, it's an entirely different proposition that you're providing your customer, and you really need to give them an educated decision process to either elect or decline that alternative service. So I hope that answers the question. And I think for me, I saw that Centre, Chris Hemsworth, and obviously Quadrant Private Equity owning that, have offered the Centre app at no cost. I didn't read the detail, but that's kind of some of the stuff that you'll be competing against. I've got another question here in relation to weddings. We run weddings. T's and C's offer no refunds or postponements for force majeure, yet we are offering postponements, but to weekdays only, no weekends, all good. All completely fine until I get to the last sentence, weekdays only. I think that I think in theory it is okay to say, well, we can only provide this alternative event at a time when the venue is available. However, if you're to sit here in March, April and say, well, we do have some weekends available in November, December, January, February, but you're not having them because you're a rebook, I think the ACCC would frown upon that because you've got the availability. I understand why you're doing it. You thought you had Saturdays booked. Saturdays are easy to sell, and therefore you want to be able to sell Saturdays again. I completely understand that, and that's a good commercial thought process. Unfortunately, I think it's going to be a hard sell from the ACCC's perspective. And I would say that commercially, in any event, are you going to have that many people around wanting to book those dates, November, December, January? I think you'll probably see a dip in event bookings generally as people come out of this weird hibernation concept that we're going to go through. So I don't know whether saving your weekends is necessary. I think A, it's possibly illegal, but you have to give it some further thought. And B, is it commercially going to achieve what you want? Possibly not. And C, is the bad PR look? Probably yes. So look, revisit that last. Yes, you're right to postpone. You're right to decline a refund. However, the weekdays only, I'd really like you to have a chat to either reconsider your position commercially or take some advice on that. So hopefully that answers the question. All right, 3 o'clock. Okay, so we were dealing with events just then. So that we've kind of already dealt with this as I answered that question. But if the event is cancelled voluntarily by you, the wedding host that we've got on the video, then totally the consumers are entitled to a refund. If the event is cancelled voluntarily, well, this is now academic post Sunday, but if the show could go on under government measures, but the customer simply cancels by election, which they were doing prior to the further lockdown measures, then that was totally on the customer, and they would lose their deposit and potentially any minimum spend that applied. If we're in the situation we are now, lockdown, as I've said, then we turn to the terms and conditions. If the terms and conditions are silent, then a postponement or a credit note is reasonable. Again, on the fly, I would like to spend some more time on the lady's comment about just offering weekdays. We've got a comment there, does a martial arts business classify as a gym? Let me come back to you on that, but I think it was quite broad. I think there was no, from memory when we looked at it the other day, we looked at it across a broad range of things from yoga through functional training through traditional gym. I think when we went to the Oxford English Dictionary, because Mr. Morrison's announcement didn't specify or didn't define, I think it was quite a broad decision in relation to, quite a broad definition in the Oxford English Dictionary in relation to a place of exercise. I think you'd be being extremely cute if you tried to say, well, we're martial arts, not a gym, particularly in relation to the intention of what the government's trying to achieve. And you also do now run the risk from not only a government perspective, but also a common law perspective. So if you had a situation where you allowed people to train in your martial arts facility because you thought there was a loophole from the Commonwealth Government's lockdown measures, you then do potentially put yourself in a position where members and employees could say, well, hang on a minute, someone got COVID-19, someone was in ICU, or even worse, passed away, and you guys really should have got on the front foot and shut this down. So be cautious and that's the thing, I've had many discussions over the last 3 days of people trying to find loopholes. And you get to the point where we've observed over the last couple of days that the economy is coming to a grinding halt in this country. And sure, there are some outliers and there's some awesome people in my LinkedIn feed telling us that they've, kicked goals, they've done some amazing things this week, but the lion's share of Australian businesses are hurting. And I think you do get to the point where you say, well, hang on a minute, let's just stop looking for loopholes and let's just suck it up, find the best way to stop the bleeding and move on and start to look at what July, August, September, October could look like. That's my question to that, with probably a little bit too much opinion added. We've been asked to bring our food caravan to a holiday park over Easter and it accepted. It's a large park, booked out. Where does this sit in the current lockdown restrictions? Let me take that on notice. My gut feel, if you'd like to email me separately, I'll come back to you on that. My gut feel is that the non-essential travel concept gets you. I mean, we definitely heard in the media release last night, Prime Minister Morrison said that no family barbecues, even with extended family, could occur in a house. So I therefore find it extremely hard to believe. But I do, on the other hand, know that certain hotels are remaining open and even offering self-isolation accommodation. So let me take that on notice and I'll come back to it. Just got a couple that have come into the chat. Perfect. So I've got a couple of comments that yes, any fitness classes are in relation to the martial arts question, and another one that gatherings generally are not allowed. So I don't know. I think, you know, maybe if you were in a hotel in the CBD and purely you went to your room and never saw anyone else, perhaps you're allowed to go and seek accommodation and stay in it. But if you're in a caravan park environment, the fact of the matter is there will be people sleeping in caravan parks for whatever reasons, because they permanently live there or they live there for a few months of the year, or for whatever reason there will likely be people there. But yeah, let me take that one on notice regarding the caravan park. It's interesting how many things crop up in the circumstances. Yeah, so I've got some more questions on the martial arts case and moving outdoors. I'll have to stop to get into the level of specificity that you're seeking there. Thank you for your questions, and they're all extremely valid, but I can't sort of, for the benefit of the overall audience, I can't go into that level of specificity here. So travel, similarly to events, if travel is cancelled, then you have to turn to the terms and conditions, but ultimately a refund or credit should be credited. There's a typo in that last sentence there, and it's interestingly because Qatar had changed their policy throughout COVID-19 in the last couple of weeks to go purely to credit. So they're playing catch up to try and keep the revenue in their bank accounts, whilst also complying with the consumer law. So that's interesting. Interestingly, some of the discussions we're having with insurance brokers is that business interruption insurance is completely off the table for most, if not everyone. In fact, if anyone has heard of a paid or even an in-process business interruption insurance claim, I'd love to hear from you in the chat box. In addition to that, if anyone's heard from a processed or a paid or in-process loss of rent insurance for a commercial landlord, I'd love to hear about that in the chat box as well. Outside of those two things that we've been looking for different angles for clients on, travel insurance is the one thing that seems to remain active, and travel insurance seems to still have some clauses in particular policies where brokers are enabling clients to access refunds for both corporate and personal. So if your travel booking for later in the year is non-refundable, I think my recommendation would be to, and this is now personal as opposed to business related, but if your travel insurance is refundable, I think you'd be wise to act sooner rather than later in the event that some of your accommodation providers or even the airlines end up insolvent. And secondly, if you book saver fares and that kind of thing, then I'd be giving your insurance broker or your travel insurer a call, even looking into your credit card travel insurance to see. Gyms, I think we've covered at length. And meal delivery services is the same. At present, my understanding is that meal delivery services can still supply. Perhaps that will come to a stop at some point and it will be purely supermarkets only. But at this point in time, they can supply and they can charge, provided that they have no indication that they'll be shut down. I'll just defer to a couple of questions and check in on the time. It's 3:10, so we've got 5 minutes. I'll take these questions on the fly and then come back. Yeah, okay. So someone said that there's cases in the States of people suing insurance companies based on duty of care. Look, my overarching comment, without being typically negative or a typical lawyer, would be the States is extremely litigious. In our the last part I want to deal with on consumer law is so one of the most common things you've seen in substitution territory earlier on was for those of you, like we were at the time, ordering groceries online, and the suppliers would say, you know, we're having availability issues, we're going to give you something else. It has to be a suitable substitute. So if you order Devondale milk and they give you 5 2-litre, you order 5 2-litre cartons of Devondale milk and they give you 5 cartons of Riverina milk, then consumer law would say that that's an acceptable substitute, move on. That said, if you ordered 5 cartons of milk and they give you 5 kilos of milk powder, you would argue that, well, that's not a suitable substitute, and you know, a refund should be available. So, and I think that's probably where just to come back to the lady that asked the question about the weekday weddings, I would query whether you have a substitution style of issue there, in the sense that it's not like for like. Sure, you can try and promote hard the Fridays and Mondays, particularly if you got creative and said, well, if you come on a Friday or Monday, your minimum spend drops, or we'll give you a 10 or a 15% discount off your overall minimum spend. Perhaps there's some creativity to be had there whilst being compliant, but happy to look further. Just before I come back to a last couple of questions, I just wanted to deal with the debtor-creditor relationship, which has kind of changed landscape since this was written over the weekend. A lot of legal commentators have talked about force majeure clauses, meaning those typical clauses that deal with what we call, you know, fire, flood, acts of God, etc. Some do include pandemic. Many and most do not. Typically a force majeure clause is not intended to slow the payment of money for historic supply of goods. So if you delivered me a truckload of beer in January and I'd not paid you for it, then I couldn't then put my hand up on a suitable force majeure clause and say, well, I own a restaurant, I no longer trade, therefore I'm not paying you for January's beer. That's not the intention of a force majeure clause. Moving along, and the thing that I say about this is the landscape has drastically changed since the weekend, because we now see that debt collection has basically been frozen for 6 months. So statutory demands have been put on hold for a 6-month period. The thresholds for claims have been reduced drastically from 2,000 up to 20,000. Bankruptcy notices have increased in nature. The ATO has given an indication that director penalty notices and ATO-based insolvency wind-up proceedings are going to stop. So in terms of unsecured creditors chasing each other for debts, we see a huge hiatus in that landscape over the next 6 months. 2 important points to note, and I made the comment on Monday. It doesn't change the position in relation to your secured creditors. So if you've got a bank who's shaky over some trading debt and wants to appoint a receiver, then our interpretation is that they won't be inhibited in any way technically, although most of the banks have said that they will provide a hiatus period. The second comment I would make, and I made it on Monday, was that if you're insolvent last Friday, you probably aren't going to get away with relying on the insolvent trading exemptions and the other measures. What I would suggest is that if you're concerned about your financial position as at last Friday, then you should engage with your accountant, insolvency practitioners and/or lawyers like us to look at what we're calling a restart plan. So do I need all of my locations? Do I need all of my plant and equipment? Do I need all of my employees when the economy starts again? And this can be quite a useful cleansing process if done properly for businesses. And we're very lucky that we live in a developed economy where these insolvency laws are available to us. So we've got 3 questions. I'm just going to turn to these. I'm just going to turn to these now for 2 minutes. All right, so I'm just dealing with we're just dealing with the wedding discussion that we've had throughout the webinar. So we'd have to look at your specific T's and C's. If your T's and C's say the wedding is if the wedding is cancelled due through no fault of ours, then we may retain your deposit. We may retain your deposit and/or claim the minimum spend. Then you're entirely right. You can offer weekdays, move on. If your T's and C's are silent on the matter, the ACCC's guidance says, well, our expectation is if you're silent, then you must provide a remedy. My concern is that if your T's and C's are silent, is that the ACCC might say, well, a Wednesday is nowhere near as good as a Saturday. And that's the thought process. But again, you're right, it does deserve some analysis if you guys can't get to a commercial position that you're happy with. Last question, I'll just take one or two more if anyone's got one. But I've got one more here. Can we charge for online workouts as it is different to club training at a reduced rate? So I answered that one before. I'll answer it again, basically on an opt-in basis. So provided that you say to me, here you go database, we've got this amazing new online workout. We've got this amazing new online workout and we sign up here, blah, 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 then that's fine. No problem at all. That can be consented to. Obviously, you've got to check the 1.5 metre rules, the public gathering rules and that kind of stuff, but generally it's fine if the intention is most people will use it at home or in open public spaces. The issue we've had with a number of people is wanting to create a situation where it's an opt-out basis. So people have to untick the box to sign up for the new X dollars per week online digital program. And what we're saying is that ACCC's guidance and the consumer law says that that's not appropriate. All right, so I don't think we've got any more questions. I'm sure all of you have got a lot more to do this afternoon. We're 1:15, so if anyone's got one more, I'll take one more. If not, we'll catch up tomorrow on leasing, probably the most prevalent topic, particularly if we don't see stimulus overnight. But yeah, I think people are starting to come to terms with the employment issues. People are starting to come to terms with the fact that their revenue is just falling through the floor. But what people are really grappling with is premises at this point, and we seek to give some guidance on that tomorrow. All right, thank you very much again for joining us. I know some of this stuff can be a bit dry. I'm sure all of you are going through your own challenges. Some of you might be seeing some great opportunity, and that's awesome if you are. But we hope that everyone's staying relatively positive and communicating properly with your teams, keeping people informed and that kind of thing. So thank you very much, as always. Cheers.